Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about wiretaps. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of conducting an investigation, the police received information about an individual from a confidential informant. The confidential informant named a person as being involved in a certain type of criminal activity, and as a result of this, the police applied for and successfully obtained a wiretap authorization. At trial, the accused argued that because the only information about the identity of the person came from the confidential informant and it wasn't corroborated by any other information, the wiretap authorization failed to meet one of the elements that must be made out in the authorization provisions of the criminal code, namely that the person must be known and that the known individual must be named in the authorization. The accused argued that because the only information came from essentially an uncorroborated tip from somebody, that didn't make this person known to police such that the authorization could be granted against them. And unfortunately, this individual lost that argument. But this case does raise very important issues on the question of what is necessary to be known for police in wiretap authorizations. If we start to water down the standard too much for what police need to know and what constitutes knowing information by police to engage in some of the most invasive types of surveillance that can exist, listening to private conversations on people's telephones or intercepting their communications, that raises serious concerns about police overreach. And we want to guard against police overreach. The Supreme Court of Canada had the opportunity here to really put a strict limit on what the police need to have to know the identity of an individual for an authorization to be granted. And unfortunately, the door is open for the police to now, as a result of this case, push it further and push it further still. And ultimately, that is going to lead to only one outcome, which is that the Supreme Court of Canada is probably going to eventually hear another case involving a wiretap authorization against a known person who is not, in fact, known to the police because the information wasn't sufficiently reliable or clear about their identity or sufficiently corroborated about their identity to allow them the authorization. And the unfortunate consequence of leaving it to that is that it will lead to a situation where individuals have had their privacy violated, oftentimes without even knowing it if the police never get any useful information and the person is never charged. And there will be no remedy for those people who've been left in the lurch in the meantime. Hopefully the Supreme Court of Canada hears a case like this sooner rather than later to put in very clear boundaries for what police can call knowing a person in order to get an authorization against them. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.